Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we are talking about a new case that came down from the Appellate Division, 2nd Department. And it's a very interesting decision, both for what it stands for legally, but also the ways in which we could learn some of the tactics that the defense attorneys and the insurance companies employ in order to limit or destroy otherwise legitimate cases. So what is this all about? This is a case that happened, it was a car crash, right? And I'll get into the facts. Maybe what I'll do is I'll start a little bit with the facts of what happened, and then I'll tell you about the appellate issue. So the facts are pretty simple. It happened back in July of 2013, and it happened in Westchester County. There was a car driven by the plaintiff, and it was struck in the rear by a car driven by the defendant, right? Very simple. And so it caused a crash, and the plaintiff got summary judgment on the issue of liability. The plaintiff was not at fault because he was driving, he got rear-ended and didn't do anything wrong, right? So the trial was all about damages, and his damages were a left shoulder tear. He had exacerbation of a left shoulder condition, which required surgery. He had aggravation and exacerbation of C4, C5, and C5, C6 disc herniations, and he had new disc injuries in the form of bulges at C3, C4, and C6, C7. He had multiple epidural injections, trigger point injections. He had bilateral radiculopathy and with nerve root damage at C5 and C6, and he had post-traumatic brain injury and post-concussive syndrome. So the case goes to trial, and the issue was that the surgeon who did the shoulder surgery, he operated on the left shoulder. He was a board-certified orthopedic surgeon. Actually, I know this doctor. He's an excellent doctor. And what happened was he testified in his examination of the plaintiff that the plaintiff had limitations in his range of motion. For example, 120 degrees was the exam, but 180 degrees is normal. So that's a 60-degree limitation. That's pretty significant. He reviewed the left shoulder MRI. He did various tests that had abnormal findings. There was weakness. So he testified about the surgery. He found partial tearing of the rotator cuff, including a slap tear, and he had to perform a radio ablation, a laser type device during the surgery. But the problem was that before this doctor even took the stand, and this is over plaintiff's objection, the court granted a motion in limine by the defendant that prevented the doctor from comparing the 2008 MRI, because this plaintiff had a prior shoulder condition, so he had a 2008 MRI 5 years earlier. And so the court precluded the doctor from talking about the 2008 MRI to show what that showed, right? And how the crash then changed the showings and the findings, and how now it's, caused by trauma, that the trauma on top of the aggravation. I mean, there were some degenerative changes from living your life, the normal painless aging process, but to what extent did this crash cause the normal painless aging process to change and, become worse, basically? And so he couldn't talk about the 2008 because when he started talking about it, the objection was sustained and the testimony was stricken. And the reason behind that was because he was never disclosed as an expert. In New York, you have to file what's known as a CPLR, the Civil Practice Law and Rules 3101D. And you have to disclose experts, and you have to explain what the experts will testify about. And I guess the plaintiff's attorney thought that this doctor was a treating doctor, so he would be allowed to testify as a treating doctor, but he never disclosed that this doctor would also be an expert, that he reviewed this prior MRI. And so the defense doctors, they had a radiologist who was disclosed as an expert, who did review both MRIs, and they were saying that it's just wear and tear. It's not caused by this crash. It's from, living life, basically, degeneration. It's from 2008, the usual defenses. So that was the problem. And then what happened was the defense attorney took it one step further. He started using the shield of preclusion and as a sword. So he was basically saying, this doctor, this surgeon wanted you to think it's from this one minor car accident, but it's not from the repetitive daily stress over years on this joint. And he made this whole, hullabaloo. And they actually got a defense verdict, right? The jury decided that it's not a serious injury, unfortunately. And then when they appealed to the appeals court issued this decision. And in the decision, they said the doctor was permitted to testify about his own observations during surgery and matters in his reports and records that were disclosed to the defendants, but he was precluded from testifying concerning MRI films of plaintiff's shoulder taken a year, taken after a prior 2008 accident where this doctor did not review until the time of trial. So that's the thing, right? He couldn't review it. He only had an opportunity to review it at the time of trial. So I guess it's a really an issue of preparation, right? Like a good trial attorney will prepare a case, will think of all the possibilities, will review what the defense experts are going to say, right? And what they're going to rely on, and make sure you can comment on those same MRIs, right? Because if you can't comment on them, then it becomes a one-sided show. They can comment on the prior MRIs, say that it's not from the crash, that it's all from, living your life. And you can't, you get basically silenced. Well, of course you're going to lose, right? And so that was the decision. And they said that because this doctor's records did not refer to the 2008 MRI or give any indication that he relied on it in providing treatment to the plaintiff, therefore he could not talk about it. And defendants had no notice either through discovery or the CPLR 3101D disclosure, which is the expert disclosure, right? And so for that reason, this doctor would not give any testimony about the 2008 MRI. And so unfortunately, they lost the case. But it wasn't just that. There were other issues in this case, and you could see what the defendants were doing. The other thing they did was they got this biomechanical engineer who's not a doctor, and he kind of testified that, the forces were so mild, you couldn't have gotten hurt from this little crash. And they had a radiologist, like I mentioned, and the radiologist was allowed to talk about all the MRIs. And then they also began to ask the jury to speculate about plaintiff working and sources of income, because in cross-examination, they asked about the plaintiffs, well, how are you, paying for your car, your monthly car lease, your rent, your bills, your cable, your Wi-Fi, So they're kind of making it out to be that the plaintiff is a liar, right? Because he's saying, I'm hurt, I'm not able to work. Okay, but then how are you, paying all these bills? And then in summation, he actually said, the defense attorney, has he been capable of working since the accident, and has he worked? How is he meeting his expenses? I totaled them up, ladies and gentlemen, $25,000 a year in expenses he has. And then he basically went on about rent. How is he doing that? The lost wages, that's another category. Is he capable of working since 2013? Has he worked since? So he's kind of making it seem like he's been working all along and this is all like a fraud, right? That's always what the defendants want to do. Not always, but a lot of the time, that's what they want to do, because if they can sow the seeds of doubt in the jury, then the jury will say, yeah, this guy's a fraudster, let's send him home with nothing, right? Where in reality, maybe, we don't know, maybe he's a real serious injury victim, and just because he has expenses, and he actually, the way that he actually was paying some of these was disability, but for whatever reason, some kind of technicality, that also didn't come into evidence, the disability. So the plaintiff's attorney couldn't say, well, no, he's getting disability checks. And so the whole thing was like this, not the truth, which is, you think the trial is a search for the truth, but this was not the truth. This is not, and the jury got an untrue version, just one-sided untrue version. And it's just, I don't know, just upsetting to me. And especially like I know who the plaintiff's attorney was in this case, and he's a really good attorney. They're a really good, highly respected firm. I think they're always in like super lawyers, so just, I feel like, maybe there were some small things that could have disclosed the 3101D, but like defendants get away with way worse. Like I was just on a trial in July of 2024, and it was ridiculous. Like they had an IME report and a 3101D for one expert, and the day before trial, they're like, we're not going to use that expert. We have this new expert. Here's a new 3101, and it was completely new theory, like completely new. And then the judge is like, you know what, I'm just going to allow it because, they gave you enough disclosure. I'm like, come on. So these 3101s, the whole thing is like just up to very much judicial discretion. So it could be like, it's like the Wild West, basically. So you can't really, completely blame the attorney. It's just, I think it's just not fair. And, look at this guy arguing, this defense lawyer. He goes, all of this costs money, like $14 for a pack of cigarettes. He has to buy food, clothing. He has a son, all of the stuff you got to pay money for. I calculated it. The total is over $25,000 a year. And then, the plaintiff's attorney objected and the court sustained it. But it doesn't really matter because the jury's hearing it, right? And he's sowing these seeds of doubt. And unfortunately, it was a defense verdict. They found that it wasn't a serious injury. And then the other thing that the defense lawyer argued was that the plaintiff's attorney orchestrated the medical care because he said, the plaintiff's attorney basically sent the plaintiff to this doctor. It was like bottomless care. The medical care his lawyer orchestrated. And so, basically that's what he argued. That they sent him to this pain management doctor, that the lawyers kind of created everything. I don't know. It was just like all of the standard stuff. But that's why I really, like I've said in other videos, it's really important to like speak to your client, get to know them, be able to tell their human story, and not just have them testify, but have their friends, their family members, their coworkers, like, circle of friends, like a little bit of a slice of life. Then it's like, if they start making these arguments, you say, wait a minute, so everyone's lying, like their mother's lying, their cousin's lying, their friend is lying, their worker's lying. It's all a big conspiracy of like, what, 10 people, 20 people? Like, come on, it's impossible, right? So that's why you want to show that and have a lot of independent doctors. But, and then finally, the other technique they did was they tried to elicit sympathy for the defendant. And so the defense counsel argued in a manner to elicit sympathy for his client rather than based on the evidence and the facts of the case. And this was a damages only case, and the defense counsel had his client come to testify, eliciting testimony that he was in the military and that he was, quote, on leave right now from the military so he could be in court. And the strategy at play came into full view on summation. Defense counsel argued that plaintiff was seeking a money judgment against this father here and his son, both of them. That's why he is here. That's why his son is here. His son took leave from the military. This was 2 weeks he had. He was here as much as he could be. He's back doing what he is doing for our great country. So, he did this whole thing like, oh, you're suing this guy. He's in the military. He's a great, person. He's sacrificing for the country, but you're suing him. But wait a minute. No, I'm not suing him. I'm suing, he's the policyholder, or the son, the driver, the father's the policyholder. I'm suing, whoever it was, like Progressive or Geico or Allstate. I don't know who the carrier was. But no, you can't say that, right? Of course, you can't say that. Shh, you'll get a mistrial. But he could do this, right? Grandstand and say, oh, he's serving this great country. It's just such baloney. But it's just like, unfortunately, that's why we have, people that are like these tort reformers that think that lawyers are a bunch of ambulance chasers, because there's so much propaganda like this and people buy into this baloney and people get brainwashed, and it's just unfortunate. But look at this. This is what he did. And it actually worked this time. It's just sad. He goes, what does serving in the military and trying to align with a patriotic spirit have to do with a damages only case to determine if plaintiff's injuries are from the accident and the severity of his injuries? It is submitted that this line of argument was solely to garner sympathy for the defendant as someone in the military serving our country and not based on the facts of the case. And then he said also, I suggest to you, this is the defense attorney, I suggest to you he was 18 years old at the time, this young man, a teenager. He made a mistake. He made a mistake a lot of 18-year-olds make when he was driving the car. He was 18 years old at the time. They make mistakes. He made one, but he is not reckless. Like, come on, he made it one mistake. He's 18, now he's in the military, give him a break kind of thing. He's serving this country, you know. So yeah, I just wanted to explain like the tactics they use. So yeah, so this was because I was looking at the briefs. This is, by the way, like I said, a summary that I subscribe to. So every week I get cases. It's called the New York New York Weekly Torts. You have to subscribe to it, and it gives you all the cases, all the new decisions, so you can stay up to date on the law. But this one was just interesting to me, so I read the decision, but they give you a little blurb that you can read the actual decision. But even when you read the actual appellate decision, it's just like a page. It doesn't give you everything. So I actually went into NYSIF, the New York State Civil Electronic Filing, as well as e-law, and I actually pulled the actual case, and I read some of the transcripts, the appellate briefs where they give quotes. So that's what I was quoting from, the actual appellate briefs of the lawyers, and that gives you more of the context about everything. But you see what they do is dirty tricks, but unfortunately this time it worked. But it's good, you got to learn from it, and then next time you know what they're going to do, so you make sure you dot your I's, you cross your T's, you serve your 3101s, or you have the doctor review all the MRIs that exist. It's a simple rule of thumb. If they have it, right? If the defendants have it, you have to get it too and have your doctor review it too. You don't want them to be reviewing and talking about something that you don't have, right? Because then they're going to say, well, you didn't tell us about it. You didn't say you were going to make, you didn't tell us you were going to comment on it, and they're going to pretend like it's a surprise to them. Meanwhile, they're commenting on it. They're saying that it's from living your life, that it's a degenerative condition, not from trauma, right? So they're commenting on it, but you can't. So then it becomes like a one-sided trial. And unfortunately, that could lead to disastrous results like this. So let us know what you think. I thought this was an interesting case to share. Our goal is helping serious injury victims and families. If you have a question or if you have a case that you need help with, just text me, 347-566-9595. Our goal is helping serious injury victims and families. Please like and subscribe to our channel, and all the best, everyone. Okay, bye-bye.